Thank you, Gene, and thank you for that introduction. And I am hoping a very swift recovery for you from Bell's palsy. And it's a very timely, I think, thing to share on her part. It's so true that things can change in a moment. I mean, I have clients where, one day I'm helping them, and then a few months later I hear they have a diagnosis. And that can be really hard also for the estate planning attorney to grow close to a client and then see something happen and then know, wow, it can happen really quickly. And so we hope that things can be put into place. What I was asked by Gene to do today is talk about basic estate planning, called it Estate Planning ABCs. And before I talk, I like to say what I'm going to say. Then I say it, and then I tell you what I said. And usually when I do that, the message gets home a little bit more clearly. So I'm going to talk about basic estate planning. And what I'm going to do in doing that is define what it is, describe what we do in estate planning. I'm going to mention some things that go wrong. And the reason why I'm going to do that is because awareness of where things go wrong helps to identify and avoid some of the biggest pitfalls, right? And then I'm going to talk about the basic documents, the basic decisions that comprise most of the estate plans that we do. And even though estate planning is not about a set of documents, it's about these key decisions that are being made in very important areas, still you end up with documents. And so you want to take a look at those, and we'll talk about what role they have in the overall estate plan. And then we're going to talk about your planning window, so when you should do things, right? And then we'll recap and have a time for questions and answers. So not too ambitious, but very important nonetheless. Just a little bit about myself. My name is John Martin, and I'm a certified specialist in estate planning, trust, and probate law. What that means is I focus exclusively on estate planning, trust, and probate law. I'm not a generalist. There's some attorneys that do everything, right? But I just do estate planning, trust, and probate. I'm board certified to do that by the State Bar of California. My office is in Palo Alto, California. I've been practicing for about 17 years. I live in Redwood City, family of four. And I help mostly families, but I help all kinds of different individuals, of course, business owners, single people who are giving everything to charity, people who are giving everything to a friend, people who are unmarried couples, families. But vast majority of my clients are people who live in this area. We're just planning for their estate, wanting to make sure they reduce costs, protect their beneficiaries, and help others. So I promised I would say, well, what's the definition of estate planning? And it's three basic areas. It's incapacity planning, beneficiary protection, and wealth transfer planning. We'll break down what each of those are in just a second. And then some people might say, well, wait a minute, I thought it was just getting a set of documents. Well, as I mentioned, it is documents, of course, at the end of the day, but ultimately, documents can change. So before 1960, revocable living trusts weren't actually used in California. And the reason for that was because probate was chosen, and it was cheap and expensive. My wife's from Maine, and I talked to an attorney close to where she lived in Maine, and I said, yeah, in California we do trusts for everybody. He's like, that's ridiculous. Why do you do trusts for everybody? You just go through probate. Probate takes a few months. It costs a few $1,000s. And I'm like, well, yeah, in California, probate takes a few years and costs tens of thousands of dollars. Like, oh, I see why you do trusts. So typically, we are going to have these documents, but there's also the question of, well, do they do what you want them to do? Right? Because when you're going to have a plan that transfers your wealth, protects your beneficiaries, do you know what these documents that are looking pretty in a binder or a folder, right, or stowed away in a safe deposit box, do you know what they actually do? Right? Do they actually achieve your goals? So we want to define what your goals are so that then we know that these documents, right, actually meet those goals. That makes sense. I want to give some examples of where things have failed. So these are specific areas where I've seen, wow, these documents didn't work. And again, the goal of this is for you to be able to identify things that are really commonly happening. So one of them is, we're trying to avoid probate. We're going to go through a definition of what probate is, right? But often we'll see that people don't put their assets in the trust, right? So they have a trust, but then the assets are not in it. And unfortunately, that means they have to go through probate anyway. It's kind of crazy, isn't it, right? You spent this time going through creating the trust, and then you didn't put your assets into it. Or maybe they put some assets into it, but not others. Or maybe they put all the assets that they owned at the time they set up the trust, but then they acquired new assets later. All of those things can happen, and then at the time when you need the trust, well, it doesn't work. You still have to go through probate. Not properly executed. So we do a lot of wills, right? And we do this very formal ceremony where people all sit down, they witness it. Not everybody goes through that. And we'll see documents that just have two witnesses' signatures, but then they don't have all of the formalities that would normally go with that, with an affidavit that's signed by the witnesses. Then that person dies, and then the court won't accept the will for probate unless we have the witnesses tracked down. We got to track down those witnesses if they didn't have all the formalities signed. Very common, actually, with wills that come across my desk. And oftentimes, what happens over like 20 years, 30 years, unfortunately, people die. And so if we can't find these witnesses, sometimes we can't even use the will that somebody signed. I've also seen things like notarized wills, right? Or witness trusts, or trusts that were signed in a different state, but they're not valid in California, or wills that were signed in a different state, but they're not valid in California. I've seen all of that. Another thing I've seen is that there's these documents, they look really nice, but they're only effective when you're incapacitated. Well, a problem is, how do you establish that somebody's incapacitated, right? A doctor establishes that. But what if you don't have healthcare privacy waivers? You know that in California and federally, you can't actually get a doctor's letter from somebody's doctor unless that person signed a HIPAA waiver. It's kind of crazy, right? So you could do all these beautiful documents, have them in a binder, but then you can't actually use them when somebody loses capacity because the doctor won't release the health letter. I know that sounds ridiculous, but it happens. Another thing is that people will do like amendments to their trust. So we see this a lot. They think, oh, I'll just go in and initial things, and I'll put a little caret and I'll write things in, and then that will be a change. Unfortunately, amendments have to be done with all the same formality as the original document. So if it's signed and notarized, typewritten, witnessed, right, the amendment has to have all of that too. Maybe that sounds ridiculous, but it's just what the law says. Another thing is we see tax benefits missed. So a really common one is capital gains tax problems with property. So properties can get an adjustment of basis, and you pay less capital gains tax, but it always depends on the title. And so we often see these not working. I'm not going to go through the remainder of these right now. Maybe we'll come back if we have time and talk about them, but know that there are lots of things that go wrong. So I mentioned these three areas of estate planning because as we start to really define these, we're going to be able to identify what the goals are of every person so that when we're doing the documents fit the goals. So let's break down wealth transfer planning. What's wealth transfer planning? Wealth transfer planning means that you're transferring assets to charities or to your family members or friends, but you're trying to reduce the cost in doing that. So cost could come from all sorts of different things. It could come from attorneys, right? Attorneys, let's say you paid an attorney tens of thousands of dollars to avoid probate, but probate was only going to cost you $2,000. Is it worth it to pay the attorney $10,000? No, that would be ridiculous. You should do nothing and go through probate, right? But what if you pay an attorney a few $1,000s to avoid a probate that's tens of thousands of dollars? Well, that kind of makes sense, right? So it's avoiding costs, but wherever those costs might come from. There's taxes. There's a lot of different kinds of tax. Does anybody remember an era where people were really worried about estate taxes? They're talking about estate taxes all the time. It's not that long ago that people with a few $100,000, right, would be exposed to estate taxes. Now, after the, wait for it, Big Beautiful Bill, it's actually the name of the new tax law that just got signed, kind of crazy name, but that law says that you can pass $15 million to anyone and not pay any estate tax. That's a really high number. So that's like less than 1% of people that have to worry about estate taxes. So that's not really a wealth transfer planning goal for most people. For some people it is, but for most people they're not really thinking about it. Income taxes. You know, you have your retirement plan, right? Retirement plans are subject to income taxes when you take them out. So that's a tax that we think about when we're doing wealth transfer planning. So those are all different things that we're looking at. We're also looking at delay and invasion of your privacy. So did you know that when a probate gets filed, and we're going to talk about what probate is in just a little bit, but when a probate gets filed, it's all public. So imagine you leave, $1 million to your daughter, right? But you were really worried, hey, I don't want her ever to become the victim of some gold digger who comes along, some bimbo or whatever, who comes along and targets her for her $1 million, right? Well, imagine that somebody could just look up in the court records whoever's inheriting money in San Mateo County or Santa Clara County, right? Wherever you're doing this probate. That can be done. You can actually go in, look up the paperwork, see what everybody's inheriting through these probate. I get calls from people, they're like, hey, can I sell this house? Hey, can I, bond your estate? Because they can just see what I file with the probate system. Same thing with your kids. If you leave some money to them, people can look up and see how much money they're getting. Sometimes even the specific assets. It's kind of scary, right? So we want to think about privacy for our family and reducing delay. I was talking about probate can take a couple years. In California, obviously, if we can shorten the period of time when your estate is being administered after your death, that might be a good thing. All right, so moving beyond wealth transfer planning, there's also beneficiary protection. So at a most fundamental level, we're thinking about the people who we're giving the estate to and if they need any protection. So underage people, right, if you have any grandkids, young kids, people under 18 cannot inherit more than $5,000 without some sort of court oversight. And we want to avoid delay. We want to avoid courts being involved for the most part. So maybe we need to name a guardian. Maybe we need to have a trustee manage something for these young people. So maybe there's also special needs. There can be special needs for young people and old people. I've had situations where I have a client right now. Her husband died about 10 years ago. And actually, she was a lawyer herself. And now she's actually running out of money. She's going to be out of money because she's paid it all to caregivers. And unfortunately, her home is reverse mortgaged, right? And they've gotten to the point where they're saying, we can't give you any more money on your home. So she's frozen with her reverse mortgage. It's not like they're going to foreclose her as long as she's in the home, but she doesn't have any more money to pay for caregivers, right? But actually, there could have been some planning at her husband's death to protect the home, to protect her assets, but still qualify her for needs-based benefits. That's possible. So we could protect a spouse, right? We could also protect people who have a disability, maybe a child who's special needs with trust. So these are really important goals, and that's beneficiary protection planning. Incapacity planning is about you, and it's about the decisions that should be made or could be made if you lost the ability to make decisions for yourself. The really famous one I think about is Terri Schiavo. Does anybody remember Terri Schiavo? This was early thousands. It was a young lady in her 20s, right? This is not just old people, this happens too. Young lady in her 20s who was dieting and she collapsed. She lost her ability to think, so she was receiving a feeding tube, right? And then her husband and parents were disagreeing over whether they should withdraw the feeding tube. They got into this big fight. It actually went to the Supreme Court, but not before President Bush got involved, the Congress got involved. So all three branches of the federal government were involved with what should happen to this young lady and her health care. That's kind of crazy, right? So you can actually opt out of that and say what your wishes would be if you found yourself in that situation. But you can also name somebody to manage your affairs, pay your bills, make healthcare decisions for you. So that's incapacity planning. So we talked about probate. What's probate? Well, probate is a process where you die and then you have stuff in your name, your home, your bank account, right? Your whatever, your tangibles. Could be artwork, could be anything you own. Car. So those assets, if they're in your name, have to go to somebody else, right? Because you can't own them anymore, you've passed away, right? You have a social security number, that can't be used for your assets anymore, right? They now have to be put into this new entity called an estate. So it's the estate of, if I die, it's the estate of John Martin, right? But that doesn't just happen. I actually had a person who, they said, well, I applied for a tax ID number. I went online, I got a tax, and I went to the bank and I said, well, it's the estate of so-and-so, and they won't let me set up a bank account. What gives? I'm like, well, you can't just go to the bank and take a tax ID number. Got to go through probate. She's like, what's probate? I said, well, probate is this court-supervised process where you file the will with the court. You publish notice with creditors, right? You file an inventory. You file a petition to deal with the distribution of the assets as a creditor claim process. There's a notice with a final settlement. There's an accounting. And then there's a distribution. And at any point during this process, somebody could come along and say, well, I'm owed money, or I have a claim, or hey, I dispute the will, and it's all published. So it's all in the paper. So for example, I had a client, we did a probate. We published notice in the newspaper, right? Caregiver shows up and says, actually, I wasn't paid overtime. So you have to pay me $750,000 because while this guy was alive, California changed overtime wage and hour laws for caregivers. And so, he wasn't aware of that. He died. And then it was a $750,000 claim after his death. Well, maybe that would have never happened had we not have this public process, right? Because there wouldn't have been notice in the newspaper. And, creditor claim forms are really easy. You just get them in the mail. You're required to send them to anybody who's a known creditor. They just fill it out. There's no charge. And then they can get a claim. And then you got to deal with it as an executor. It's not enough to avoid probate to have a will. So if you have a will, the will still needs to be proved, right? And so it's either for people who die without a will or people who die with a will. You've got to go through probate. So what goes through probate? This is going to be key for understanding how you can avoid probate. I was saying any asset in your name individually will go through probate. So that's anything like a house or a bank account. But if you hold something in one of these areas over here that's in the blue box but not the green, then you can avoid probate. So the blue box says joint tenancy assets, assets that pass by beneficiary designation, and that could include a retirement plan or an annuity or a life insurance policy, and then also transfer on death or pay on death accounts. So transfer on death, we can register any account we want, POD or TOD, to a beneficiary. That avoids probate too. Joint accounts, that avoids probate. Now there's going to be drawbacks of using those kinds of accounts, but it avoids probate. Right of survivorship for joint property. So you can hold, a lot of people here probably hold their home with their spouse and your joint tenants. So joint tenants means you're both on title, and if one joint tenant dies, actually all automatically passes to the surviving joint tenant. So that doesn't have to go through probate. Then there's some things that you don't own and they don't go through probate. If you gifted something to your child before you died, well, that doesn't have to go through probate. If you put something into a trust, that doesn't have to go through probate. So some people say, okay, well, why don't I do this really cheaply and easily? I'll just register all my assets jointly with my spouse, but if my spouse dies, I'll just register all assets jointly with my child or whoever I want to lead it to. Kind of sounds like an easy solution, doesn't it? Well, there's some problems with this. One is that you can't guarantee the order of deaths, right? Let's say your child dies first. Well, now you have this taxable transfer from your child to you, right? You also can't control what happens if your child gets divorced, if your child gets sued, right? So let's say your child gets sued. You could lose your home, right? Because your child is now a creditor to this judgment lien holder. They could go foreclose against the house, right? You say, well, that was just to avoid probate. Sorry, they own this interest in property, so they can now sell your home. What if your child goes rogue? Now, I know that a lot of people are like, my child would never do this. I just had this happen. I had a lady, she actually, a really sad story. She's about to go into surgery. So she thought I could die. It was actually a really high-risk surgery. And she's got like 5 kids, but her son was living in the home. And he said, Mom, put the home in joint tenancy with me, right? Because you don't want to have to go through all the costly probate. I'll divide up the estate with the other kids. I'll make it all fair. Oldest son, she says, I trust you. She put it in his name, joint tenancy with her, right? She survived the surgery. She's actually made a full recovery. Says, could you please sign that back over to me? No, it's mine, right? We got to sue him. That's ridiculous. I can't believe it, right? She can't believe it. But yeah, you actually cannot force somebody to sign back over the deed, right? Now, I would say maybe there's some other reasons why that was inappropriate, like she was about to go into surgery, she was under a lot of pressure, right? This is inappropriate that he's saying no, but that's a different story, right? So in a limited cases, though, we sometimes do recommend joint tenancy. Like I think it might be nice, since it takes about I don't know, 3 weeks to get a death certificate when somebody dies. What if you, as the child, your parent just died, and you need to go in, you need to order the death certificate? Well, that's done through the funeral home. But you know what? They actually like to have a down payment before you can even fill out all these forms. I don't know if anybody's walked through this with the death of a loved one, right? But they don't just say, sure, we'll do the funeral, and we'll do it at cost. They say, please give us $10,000, right? So you write out that check. Where is that money going to come from? You don't have access to your parents' finances yet, or your loved one's finances. And actually, it's going to take some time to do that because you got to get the death certificate. So actually, sometimes I say maybe it's better to put a little bit in a joint account so that your child or somebody can have access to that without any kind of process at all. The only drawback is we can't actually force that child to use that money for that purpose, because joint tenancy is just a gift to that child. So there's no document that says you have to use that trust or that joint account for that purpose. But usually the kid is pretty good about doing that. Okay, what about pay on death and transfer on death accounts, right? That's not a joint account, so you're not immediately making a gift to somebody. You're saying, I'm transferring it at my death. Couldn't we just register all assets in transfer on death, pay on death? And actually, a couple years ago, Sacramento, the legislature, they came up with a transfer on death deed. So you, in theory, could do this for everything. You could do it with your home. You can do it with all your bank accounts. You can do your investment accounts. Maybe you have a really simple estate. So you just say, well, I'm just giving it all to my daughter. I'm single. And I'm just going to put everything transfer on death, pay on death. And actually, there have been a couple situations where I did do this, right? But they were really simple. The client was a lot older. So I wasn't really worried as much about like contingency planning. But for most people, it's not going to be a good plan. And here's why. There's no contingency planning, right? What if daughter dies first? There's also no plan here for incapacity. Remember, that's one of the big goals. Transfer on death is only effective at death. So how's this person going to come in and manage your affairs while you're alive? And just like joint tenancy, there's no instructions for how these funds should be used by the person who gets them, right? So when we do a trust, we say at death, go in, establish all the final debts, establish all the final obligations, pay for the funeral home, pay for all this. Well, that's a fiduciary duty. That's a legal duty that trustee has to do all those things. There's no duty with pay on death, transfer on death, right? So just like with joint tenancy, maybe that'd be okay for some small things, but not for everything. There's another thing that happens when you have multiple beneficiaries, okay? I had this happen. It doesn't happen with every asset, but for some assets, the beneficiaries have to agree on how they divide the asset, okay? So this is definitely true with real estate, but it's also true with things like bond accounts, right? So let's say you have bond accounts. Has anybody gone in to divide a bond account after the death of a loved one, right? Did you know that they can't just evenly divide all bonds? And that's because, there's lot numbers, there's a call on the bond, but you can't take out the bond before it's matured. So what they'll do is they'll come up with a division strategy between multiple people, but it's not going to be 50-50 of every bond. I had this happen. I had this guy, he passed away. He was leaving everything in TOD to his niece and nephew. They actually hated each other's guts. I talked to the niece on the phone. I said, we just need you to sign off on this paperwork at Merrill Lynch. Sign on this paperwork, and then you will get $2 million in bonds. She said, I hate my brother. I don't care if my brother gets $2 million. I hate him so much. I am not going to sign anything. I'd rather not get anything myself. I want him to suffer. She actually said that on the phone to me. I was just shocked. But you know what? I've become a little cynical because I've heard it so many times. I've heard people say these really hateful things. And you're like, well, my kid won't do that. Probably not. But I've heard people say that. So somebody's kids are saying those things, right? So we had to go to court, and we had to get a court order. That cost many times more than it would have cost many times. I want to say it was like, at the end of the day, $20,000 in legal fees to get an order dividing this one account. They could have done a trust for $4,000, right? So you decide which one would be the better and more cost-effective plan. So how does a trust work? How does a trust work in dividing assets and holding assets and avoiding probate? It works this way. You have a document. A document is a document. You can put it in a folder. You put it in a file, right? A trust is an entity, though, at the same time, right? So a will is a document. A trust is a document. But a trust is also an entity. So what are entities? Entities are things that exist that are other than a person, right? You're a person, I'm a person. Coca-Cola is an entity. It's a corporation. Corporation can own property. It has a CEO. It has shareholders, right? If the shareholders of Warren Buffett, if the shareholders of Coca-Cola all die, Coca-Cola is still a company. It's just that the shares passed hands to somebody else. Same thing with a trust. You can set up a trust. You're the owner, the beneficiary, the settler, the person who sets it up. You're the trustee. But if you die, then the trustee changes, the beneficiary changes, but the trust is still there. And the assets that were in that trust are exactly where they were before you died, right? And then this document is saying what to do with those assets. So that means we don't have that problem like I own things individually and now I've got to go through a probate because they're all in this entity and that entity survives me. But unlike a corporation, this is kind of weird. If you really think about it, you don't have to register the trust anywhere. It's also a little dangerous. But once we sign a trust, there's no government registration. I don't have to go to the county to file it. I don't have to lodge it with the court. Nobody knows about it. But then I can put property into it. I can put a bank account into it. I have no obligation to tell the county that I actually have a trust when I put my home in the trust. Could that be a problem? Actually, yes. We've had people who passed away and they said, or the relatives came to me and they said, well, the title deed says there's a trust. I'm like, okay, do you have the trust? No. Where would I find that? Well, could you go through files, and talk to the attorney? And well, there was no attorney. And well, okay, do you go through all the files, the notes, and there's nothing, I can't find a trust. Okay, well, we're still gonna have to go through probate. And actually it's gonna be an intestacy. So even though she might have named you under the trust, now we're gonna have to share this with all the other intestate heirs. What? That's not what she would have intended. Well, I'm sorry, unless we can find the trust. Trust isn't valid. So maybe it'd be good to have a plan in addition to the trust on how you would use the trust. We'll talk about that in a little bit. But a trust preserves privacy in that you don't have to register it. So because you don't have to go to court, you don't have to lodge it anywhere, well, now nobody knows what people got under the trust. So your daughter, right? I would have been able to look up with the court system, know exactly what she received. But if you have a trust, you put that $1 million in the trust. I never even get notice of your death, right? I mean, maybe an obituary could be filed. But other than that, I have no right as a third party to know what you left your daughter or to see what your estate plan is. That's a really big difference versus having the public trust system. How else might that help to have that privacy? What if I'm a caregiver and I'm thinking, oh, overtime claims, right? But this was several years ago and now I've been, off the job because my client went into assisted living for the last year. Well, I never saw that there was notice in the paper. I never saw the will. It was never public. So maybe it's way less likely that I would file a lawsuit because now it's all private. So it minimizes the chance of dispute. And of course, by writing things out, and this is true with a will too, by saying who gets everything, who's the trustee, maybe having an order of trustees, you're going to minimize dispute. Because if everybody knows who's going to be in what role, where all the assets are going, how they're going to be divided, who's responsible. So I'll give you an example. Tangible personal property. Wow, people really fight over tangible personal property. I actually had a client, her sister was trustee. She came into my room. She's like, I think my sister stole stuff. And I'm like, well, okay, let's make an inventory. What are the things you think your sister stole? She said, it's a throw rug. And I used to, when I was growing up, I would play on this throw rug. It's nowhere in the house. Like, well, it's a throw rug. And she started crying. She's like, I need the throw rug now. And she's like, I don't care what the throw rug is worth. Find something else we can sue her for, right? We'll sue over that if I can't get my throw rug. Yeah, I've had that conversation. So people, when they have a system by which the tangible personal property can be distributed, documented, minimizes the chance of dispute. Because then they can see who gets what. And I'll come back, I'll give another example if we have a little bit of time on how the house can be divided. Of course, costs can continue on for children. So remember we were talking about underage people have to have something managed for them. Well, trust and a will can provide for ongoing management of an estate for children. Maybe a continuing trust that terminates when you reach a certain age, like 25 or whatever. And then you can have your assets distributed to you. Okay, so let's move on from the world of trusts and avoiding probate because that was really important. So I spent a lot of time because it's really important for people to know, okay, it's good to avoid probate. But let's talk about some other documents and how they relate to that whole big picture of wealth transfer planning, beneficiary protection, incapacity planning. And I think one of the biggies outside of the trust and will is going to be the power of attorney. Power of attorney, often overlooked document. People will not really think a lot about it. They just, sign a generic power of attorney. They don't give a lot of thought into it. Actually, it's a very important document. And the reason why it's really important is because of where people have their wealth. Where do people have their wealth today, these days, right? I mean, obviously, there's some really rich people. They have it all in their stock. But for most people, it's their home and their retirement account, right? Most people, home and retirement account. That's where most upper middle class people have all their wealth, right? So retirement accounts cannot go into a trust. Retirement accounts are regulated by federal law. We call them ERISA qualified plans and unqualified plans. And you, as the employee owner, have just your name on it. If you tried to put your spouse's name on a retirement plan or transfer it to a trust, your financial advisor would laugh at you. They said, no, you can't do that. You've got to have it in your name individually. But you can change the beneficiary, right? And we talked about beneficiary designations. But how will a retirement plan be managed if you become incapacitated? Not the trust. It's going to be a power of attorney. Very important because let's say you have a minimum distribution. Has anybody almost missed or did miss, you don't have to raise your hand, I don't want to embarrass anybody, a minimum distribution, right? You reach retirement age, you're supposed to take these shares out of your retirement plan. If you miss them, you pay a penalty, you pay tax. It's really serious. If you become incapacitated, who's going to do that for you? It's going to be your power of attorney. Power of attorney can also do other things for you as well. Remember I mentioned that lady who now she doesn't have money to pay for her care. A power of attorney can do special needs planning. We can put in the power of attorney that they can set up a trust, which is a asset protected trust, exempt from creditor claims, exempt from qualification rules for Medi-Cal, Medicaid, and SSI. So the power of attorney can do a lot of planning, but we actually have to put those provisions in the power of attorney from the get-go to make sure that they can have the power. And most people don't have those provisions in their power of attorney. They just have the basic, A, B, C, D, all the way down to N powers, but they don't go extra. And one that's near and dear to my heart as well, because I like putting things on credit cards to get the rewards points, right? Get the cash back. I'm a cash back person myself. But did you know that if you pass away, your rewards balance goes away with you? Your spouse can't go in and say, American Express, Chase, whatever, can you transfer over those miles to me? No, they go away. So if you're incapacitated, your agent can go manage your credit card for you, right? It's the agent. So we like to always make sure there's a mention of credit card, being able to manage the credit cards under the power of attorney. Okay, enough about power of attorneys. Healthcare directives. So healthcare directives are very important because if you ever became incapacitated, you're going to want to make sure that somebody can decide things like placement, where do you live? Especially after the pandemic, this started becoming a really important topic for people because people were saying, wow, look at the lockdowns that happened inside care facilities. People didn't see their kids, grandkids for like over a year. Really crazy, right? So a lot of people were like, maybe I should do in-home. I'll be in-home. And then I can have caregivers and maybe there'd be easy access. Or like there's also a risk of infection too, right? For other things, flu, when you're in a shared space. There's also disposition of remains. I had a client, this kind of crazy situation, 6 kids. Half the kids were one religion, the other half of the kids were another religion. Is because 2 different spouses, right? And each different religion, so they each followed the religion of their mother. Well, they had different opinions on disposition of remains. So my client said, hey, my mom's priest will sign an affidavit saying that she wanted to be buried. Here's the burial plot, right? She said to her priest, this is what she wants, so shouldn't she be buried? But the agent, under the power of attorney for healthcare, is the one who can decide that. The agent said, no, she's going to be cremated. And my client said, well, can't we sue? And I said, no. If you try to do that, the judge is going to laugh at you because they're going to say, no, California law is whatever's in the healthcare directive, right? And if it's blank, if it doesn't say anything, it's the agent. They can make whatever decision they want, right? Even if the priest signed an affidavit saying that this is what she told me in her confession, right? I don't know if they can do that, but this is what she told me outside of confession. At the time before she passed, no, it has absolutely no bearing whatsoever. It's whatever the agent says. So you better be darn sure you write that down if you think your kids are going to fight. Even if you don't think your kids are going to fight about it, you should write it down, because a lot of people assume that their kids know what they want, right? But it's a huge burden sometimes for them to guess what you want. And I'll talk a little bit more about disposition of remains, because I just learned a lot about this, and I think it's kind of cool, kind of interesting anyway. And then funeral arrangements, I like to see the actual plot listed if you own a plot. I want to see your advanced care contract listed. Do you have a Neptune Society cremation contract? You can prepay for cremation. We want to see the contract number in your advanced healthcare directive so that at the time when you pass, we don't lose that benefit. Some people don't know that their loved one has a Neptune Society or other cremation contract. So I wanted to talk about some other options besides burial and cremation. I want to give a little bit of context because I think it's kind of interesting. I saw a presentation on this on this subject recently. 50 years ago, 70% of people did burial. Today, 70% of people do cremation. It's totally inverted. The reasons for that are mostly cost, but very interestingly, it depends on what region of the country you live in. So if you're in the south and center of the country, people still bury by majority. And if you're in the west and northeast, people mostly cremate. Isn't that interesting? And there's also other options besides cremation that are available. These are kind of new options, and they're now becoming more and more accepted and practiced. Green burial. So that's where you have a compostable coffin. Human composting, that sounded kind of weird to me, but then I looked at it, I'm like, actually that's kind of interesting, because they will, and I know Washington State is doing this right now, and California now is getting a facility soon, but basically the body is transported to the facility, and then over a month-long process, they speed the composting process. The body becomes soil, and then instead of the cremated remains, the family loved ones can receive the soil. And actually, I thought this was really beautiful. They took the soil, spread it out among family members, and each of them planted a rose bush, in their garden. I thought that was kind of cool. But of course, there's also just classic burial. And then the cremation has also changed too. It used to be it was just incineration, by fire, but now there's also water cremation, which does not involve any emissions, and slightly different end product. So then healthcare privacy waivers, I mentioned this early on, very important. And do you know what's kind of sad about this? I mentioned, you need a HIPAA release. The HIPAA statute also says that your HIPAA release expires 2 years after you sign it. I don't know how to really deal with this, besides saying come back every 2 years and re-sign your HIPAA release. Unfortunately, that's the right answer. But a lot of doctors will fudge this. They see a 5-year-old HIPAA release. They're breaking federal law when they do that. HIPAA releases expire every 2 years. Really frustrating. You kind of, wish that Congress had thought a little bit about that before they created that regulatory scheme. And it's been since 1997. They haven't done anything about it. But that's what we have. But you want to definitely have those waivers. What about, will these documents, and I'm moving away a little bit from the documents, talking about the practicalities. Will these documents actually work for you when you need them? And we talked about somebody who passed, but their loved one couldn't find the trust. What about if you did a healthcare directive, but then you have a medical emergency, you're in the hospital, will the healthcare directive be followed? So if you have a healthcare directive, do you take bike rides with the healthcare directive in your back pocket, right? Do you carry it with you in your car, right? If you're traveling out of state, will you, let's say you have Kaiser, right? Or you're with Sutter Health, or you're with PAMF. If you're out of state, obviously that's a different network, right? So for the most part, I guess there are some, in-network hospitals maybe, but they don't have access to any of the health records that you have with your doctor. It's kind of weird, isn't it? They talked about this in 2007 when healthcare reform was being debated. And Congress, some people in Congress said, maybe we should have a national registry of healthcare directives so that no matter where you are in the country, people can, no, it's going to be too complicated. I'm like, is it really that complicated? I guess it's too complicated. So we like to set up our clients with an emergency contact card where you're linked with cloud storage, right? But either way, you need to think about some sort of practical solution so that your healthcare directive will actually be found. So getting it to your doctor is step one, but then coming up with some sort of system so that family members, loved ones can be reached, and then your healthcare wishes will actually be carried out, especially if you want something like a DNR, like you want to discontinue life-sustaining treatment. Okay, storage of originals. This is also kind of weird, and maybe this is becoming a common theme, where it's like, why is the law like this? But it is, don't shoot the messenger. One of the things that we have with trusts and wills is that a copy of a trust can be valid as an original. So if you have a trust that's lost, right, you no longer know where the original trust is, never fear, we pull out the copy, you still can avoid probate, right? Everybody will accept that trust. Maybe if there's a contest of the trust, you've got somebody challenging it, saying that it was doctored, you could have some issues if you don't have the original trust because the wet signature is better than a photocopy. But except for that, right, you have no problem having the trust be honored and followed. What about a will? You'd think that since a will is generally a smaller document, most people are moving all their assets via trust, it'd be simpler or just the same as a trust. No, the law says if a will original cannot be found, it's presumed that you revoked it. And it's very old-fashioned, right? So you actually have to think about safeguarding your will and keeping it in a fireproof location, flood-proof location, so that it won't be destroyed. Because if it's burned up, right, and you're incapacitated and you pass and nobody can find your will or you can't re-execute it, and then there's any kind of need to probate your estate, there could be big problems, right? What if your trust goes to somebody other than your will? That's huge if you can't find the will and you have, your intestate heirs are different from your trust beneficiaries, right? So then you have a big problem if the will cannot be probated. And I had that happen. I had a client whose mother passed away and the trust went straight to the grandkids, right? The will could not be found. Nobody knew where the will was. And so the client came to me, they said, well, all the assets are in her name individually. Nothing's in the trust. The trust all goes to our kids. Are you saying we could go in and set aside the gift that my mom left to our kids? Absolutely. If you wanted to go in, you could file probate. You'd say there's no trust. So you could say that your mom's planning is done and then you get her whole estate. And they're like, we don't feel good about that. I'm like, well, you could also just tell the court you believe that this should happen and we'll see what the judge says. And actually the judge said, yeah, we're going to go ahead and avoid probate and let it all go into the trust. But that was our old judge. And actually, I don't think our judge today would have done that. So I think that we would have a serious problem and it would have gone to the people that the mother did not intend. And by the way, doesn't that sound weird also, that one judge would do something and another judge would not? That's actually all across California. There's different results depending on what county you're in, right? Based upon how your trust reads, based upon what the judge in that particular county thinks is good or bad. Sounds weird, and it's because it is weird, right? So it's inconsistent based upon where you are. Okay, this is now wanting me to do this. So amendment, we talked about the wrong process for amendment, like initialing. But a question that comes up a lot for me is, well, when should I amend my documents, right? Maybe this applies to some people in here. Maybe you set up your estate plan a while ago. You're not sure if it needs to be updated. We would love to sit down with every one of our clients every few years, like every 2 to 3 years. That's not because we just want to generate a bunch of work. It's because we don't know what we don't know. Has there been a change in law that affects this particular plan? What about a change in your family? Do you have any new grandkids? What about a change in your assets? Right? Do you have any new properties? Is everything in the trust? Because remember, we don't want there to be a probate. So if there's assets outside the trust, if you haven't tracked everything, and then maybe if something changed, like let's say you left everything to your son, right? And now he's married, and actually I don't want to pick on anybody if anybody has this situation, but say his spouse, it's just a really troublesome marriage. And, now the parent is worried about there being a divorce, right? And they're thinking, well, gosh, maybe I shouldn't leave everything outright where it's going to be vulnerable in case there's a divorce. Well, we could create a trust that would protect the inheritance so that, it would be insulated from the risk of lawsuits and creditors and divorce. So these questions won't come up unless we have an opportunity to look at it over time. But the biggies are going to be birth of a child, grandchild, acquisition of new assets, and a change in the law. Of course, it's hard to know if the change in the law might affect you without talking to somebody who's familiar with that law. Appointment of guardians, the person, are also done in either a will or a standalone document. And what I mean by that is the person who makes care decisions for minor children. That's typically done in a will. Again, another document can do it. General assignment of assets. Everything good? Okay. Assignment of assets would be where, remember I was like, you leave something out of your trust, right? We can do a prospective assignment of assets. So the way I do this is I have a document and it says, I hereby transfer everything I own, whether owned now or after we're acquired. Now, unfortunately, that doesn't work in every county in California, but it does work in San Mateo County for now. So we have all of our clients execute a document like that, having some sort of practical plan to make sure there'll be cash available for your end of life and death expenses. I mentioned care costs, and so I don't want to go over this again, but know that there's a lot of options for preserving needs-based government benefits. Okay, does anybody want to hear a little bit about the big, beautiful bill and some of the key things? I think it's kind of interesting. There's a new thing called the Trump account. Starting next year, any kids that are born in 2025 and later years will automatically get an account with $1,000 in it. I mean, that's kind of nice for anybody with grandkids, right? And also, any individual can fund $5,000 into each account per year. And then that amount can grow tax-free. So think of it kind of like an IRA for your children. Your children don't have to be working. You can just fund this. And then later, they're going to have maybe something that's been built up. But we like to say, first max out the 529 because it's a little bit better. Then you can put more into it. If you have some left over, you could do the Trump account. And by the way, I didn't come up with that name. That is what's in the law. So then new deductions. I like how there was like kind of a, sort of felt heavy right as I said the word Trump account. But anyway, so then new deductions. This was kind of cool. The standard deduction is bigger than it's ever been before in history. So it's now reached, I don't know why I put 24,000, it's like 30,000, which is double what it was 10 years ago at 17,000, the joint standard deduction. Most people, that means they're not going to be itemizing anymore their taxes if you're an itemizer. So the vast majority of people. There's also now, temporarily for the next several years, a 40,000 state and local income tax deduction. So if you recall, under the 2017 Tax Act, it was a 10,000 limit when you're itemizing for the state and local income tax deduction. But now for a short period of time, so through 2028, there's a 40,000 state and local income tax deduction if you're itemizing. But it phases out for joint filers once you're over $500,000. But if you're under $500,000, you have that full 40,000 state and local, which is kind of nice. And then there's a new floor that applies to charitable contributions when you're itemizing. And there's also another rule that lowers your overall itemized deductions. So basically, if you make a gift of $100,000 to charity, you can only deduct $95,000. All right. I wanted to mention a little bit about, how are we on time, Jean? Are we good? Good? About providing for minor beneficiaries. So when people are young, you are obviously not going to be certain what their life is like. If you have a 5-year-old grandchild or child, 5 years, 10 years from now, 15 years from now. A lot of people will come in, they've got a 5-year-old kid, and they say, John, I'm a doctor, and my wife is such and such, and we're really highly educated, and our kids are going to be just like us. So I think that at 18, my son should be our trustee, and I think he should get his whole estate outright, right? And he doesn't need any protection, doesn't need any management. I'm like, dude, your son's 5. How do you know that, right? It's like, well, if I'm going to do my job as a parent, he's going to be fine. And I'm like, well, even if you do your job as a parent, maybe not. Maybe something might happen. Maybe he has an accident. Maybe, you meet the wrong person, and he's like, well, what would you recommend? Well, I think let's just extrapolate a little bit and think about what happens with most people. So most child psychologists will say that the brain is fully mature when you're around 25 years of age, right? That's not across the board, but I think it'd be very reasonable to say that around 25, you can have access to your inheritance, right? 18 legally, but gosh, who knows a really mature, sound, 18-year-old? They exist. I'm sure they do. I don't know any of them, but I'm sure they exist. But for everybody else, I think management through age 25 is going to be better. And then if you come back and your kid at 19 is already married, they've served, in the army or something, and they've already gotten out and they've started a business, maybe you could say, wow, I'll lower this age. But until you get to that point, I think let's just make a reasonable decision based upon what's more likely to be the case. And then also providing for guardians in the trust. If let's say you got minor kids, how are the guardians going to be able to have access to funds and be able to maybe make sure their house is appropriate for the children, make sure that trips can continue, make sure that other family members can continue to visit the kids? We can put provisions like that in the trust to make sure that kids are going to be provided for, not just with money, but also with these more soft different decisions that we can make. And then also think about taxes. So I just wanted to say a word because I get a lot of questions on this. Proposition 19 was passed in 2021, which means that there's no longer an ability to pass most real estate onto children without getting a reassessment. So that is something that we have to be aware of at the time of death. And also cohabitating unmarried couples and rental property owners. Some people decided not to fund their IRAs, 401ks, because they said, well, I'll just build up a bunch of rental properties, and then I'll pass those on to my kids, and that'll be kind of like the 401k. The problem with that is that they're now going to all be reassessed on that real estate when they pass it to their kids. Probably their kids won't be able to afford those rental properties when they pass it on. So they could think about having some kind of alternate strategy, maybe providing for the sale of everything at their death, or doing tax-deferred exchanges, or maybe getting into something like an REIT. And then unmarried cohabitating couples. I actually have this happen a lot where somebody says, okay, well, we're not married, but we're going to have a trust. We'll hold our half of the home. We're going to leave it to each other. If either of us pass, if you held on to your home for a really long time, that's going to cause a reassessment of half of the home. So if you've been cohabitating for 20 years, owning a home, right, and then somebody dies, that could be an increase of tens of thousands of dollars in your property taxes all in 1 year. So a lot of people are unprepared for that. We actually have strategies to avoid that, though. We could set up maybe a legal entity where then, because there's not a change in control, when one of the unmarried partners dies, there's no reassessment of the property. So these are important things that people may not be aware of. They could also get married too. Okay, so then word about retirement plans. So retirement plans have changed over the years. It used to be that people would leave a retirement plan to a kid and they had their lifetime to withdraw it. And what was great about that is it defers taxes even more. And our education would be to children. We would say, hey, now that you inherited this retirement plan, stretch it out, because look at the exponential growth that this will get. Tax deferred if you stretch it out. Don't take it all out now. Well, now, unfortunately, they have 10 years. And during that 10-year period, a child has to take everything out. But there are some limited exceptions. So first of all, it's important to know that charities don't pay any income tax. I have people that say, well, here, John, here's how to write my trust. First, give $100,000 to charity, give the balance to my kids, and then give my retirement plan to my kids, right? Can you draw that up for me? I say, well, wait a minute, time out. Did you know that charities don't pay any income tax? Well, of course. Well, did you know that your retirement plans are subject to income tax as the money comes out? So we should give the first assets that go to charity should be your retirement plan. Why? Because charities don't pay any income tax. So whatever they receive from your retirement plan is going to be tax exempt. So now $100,000 of your retirement plan that would have been reduced by income taxes if your kid got it, right? Instead of giving it under your trust, let's give that to charity under your retirement plan. So now we actually have a bigger pie for the overall estate. We're giving more money to the same number of beneficiaries. I think that's kind of cool. So then another thing is that because of this 10-year rule and because of income tax rates for our older clients or clients who are retired, or maybe a year where you're making less money, maybe you took a sabbatical year or something like that, Roth conversions. Roth conversions are becoming much more popular because of the Secure Act. I don't do Roth conversions. CPAs and financial advisors are involved with that. But it's important to cite the issue, to point out the issue for our clients, make sure they're aware that usually the math pencils out really well when people are in a lower tax bracket, right? When they're older, and if they have a big retirement plan, because what they do is they incur taxes now on the retirement plan, get it into a Roth, which then when the money comes out, it's not subject to income taxes. It's going to be better for their kids if the kids have to withdraw everything within 10 years. All right, so when should you be doing all of this? So I think the natural inclination, maybe it's tied to our desire to survive, is that we have an expectation of when we're going to become incapacitated and when we're going to die. So maybe if you looked at mortality tables, you're like, okay, I'm a male or female, likely to die between my late 70s and mid 80s, right? And here are my potential causes of death. It's going to be, this, or that, right? And then incapacity, well, maybe you think about relatives of yours, well, probably some limited period of time prior to dying, and it will be dementia, but it's unlikely to be, before I'll get my estate plan in order. Remember Terri Schiavo? She just collapsed, right? There was no planning window after she collapsed. I just did an estate plan where I was able to go in. This was a 47-year-old gentleman. He had a diagnosis of pancreatic cancer. His decline was so fast. It was weeks. But I went in. He was still fine. He was on a lot of painkillers. But you know what? He had one child, right? And he clearly was able to express that he wanted everything to go to his son. We did everything. It was on his deathbed. About a week later, he died, right? But then I just got another email a week ago, right? And this person's like, my brother, he's in the hospital, right? He's got stage 4 cancer. He needs an estate plan. He's got a couple $1 million. I need you to go into the hospital. Problem is, he's on such powerful painkillers, he can't communicate, right? He comes out like briefly, but he's in such pain that he really can just say a few words, right? I'm like, I'm so sorry. I can't do the estate plan for him if he can't communicate his basic wishes, right? Even if it's simple. So you really don't know your planning window. You don't know how quickly this will all happen. This happened to my dad too, actually. My dad, we were all on vacation together, riding bikes, having fun as a family. And my dad's like, wow, I kind of feel a little something. He checked it out with his doctor, stage 4 cancer, metastatic melanoma. And actually 3 weeks after we got back from our vacation, he had passed away. Now, thankfully, he had a comprehensive estate plan that he had put together, right? But what if he hadn't had that, right? What if he didn't have something for my mother, right? That would have been an absolute disaster because he owned a business, right? He had a home, he had all these things. So you really don't know your planning opportunity. It can happen really fast. I think Jean mentioned that earlier. You don't know what age, right? You don't know what stage this might happen in your life. So go home, set a deadline for yourself, make an appointment. It doesn't have to be me. There's many other estate planning attorneys that help. I think one of the things, and the reason why we do encourage people not to do this DIY. It's not that, the DIY stuff doesn't work all the time. It's just that you don't know what you don't know. So how would you know if the assets are going to be properly funded? How would you know if you're doing a general assignment that would work in the county where you are? How would you know if the trust is going to deal with the tax issues that I brought up and the probate avoidance issues, or be valid in every state the way you execute the document, right? We talked about the witness formalities and the notarization formalities. So with that, hopefully I didn't scare everybody too much, right? And I'd like to take some questions. When we take the questions, remember, you can ask about a situation, but try to keep it general, because I don't want to give specific legal advice, right? And you can always say, my friend is going through this situation, and then I can answer that question for you. Go ahead.
So what people into that in California?
Great question. Well, do you live in California?
Yes.
Okay, so we have 50 states. 50 states with 50 different probate codes, with 50 different potential probate processes that could happen if you own property in all 50 states, right? Could you imagine going through 50 probates when somebody dies? Yeah, if you owned a property in all 50 states and didn't have a trust, you'd have to go through 50 probates, right? So I've had clients that have owned property in 3 or 4 states when they passed. One of the great things about a trust, regardless of where you set up the trust, whether it's California or some other state, is you can avoid probate in every state where you own property. Just put it all in the one trust. Why would you do a California trust versus a trust in some other state, right? Well, actually, you could choose, because choice of law, we have freedom of contract. It's a constitutional right. So you could actually opt into the state law of any state you want to. I don't know why you would opt into the law of Wyoming or Montana, right, when you're in California. And if you have an attorney who's a California attorney, they're not going to do that because they know California law. So they're going to write your trust according to California law. The reason why people usually say, can I do a Nevada trust, is usually because they're trying to avoid California income taxes. So they say, oh, can you put all my assets in a Nevada trust? Unfortunately, that doesn't work. So California says if you live in California, you earn income in California, you pay taxes in California. You can't just set up a trust in Nevada, put your money in there, and avoid tax. You actually can do it, but it's an irrevocable trust that you would set up in Nevada under Nevada law, but you wouldn't actually be able to take income out of it. Yeah, her question was, John, how do you charge for amending a trust? So you obviously charge something for setting everything up, but then once people have it, are you charging them for updating it? Yes, we do charge for updating it, but we provide people options for how they want to deal with it. So this is my personal practice. Other attorneys may have other ways that they do it. So when we do an estate plan, right, first of all, we generally charge a flat fee for doing that. So I have something called core planning. I'll just tell you right now, for an individual core planning, which is like the basic estate plan, we have a $37.50 charge for an individual and a $47.50 charge for a married couple. And it's like basic documents, basic planning decisions, 3 meetings, review of all your assets, beneficiary designations, and people end up with a trust, power of attorney, healthcare directive, counseling over different tax issues, their guardians, et cetera, right? And then a year after their signing date, I invite them to join a client care program. It's opt-in, so we don't force you to join it if you don't want to. But the client care program covers a lot of these things I talked about as problems. Like, where do you keep your documents? So I have a fireproof vault in my building in Palo Alto where I can store a will and trust if they stay continually engaged with me. I have a cloud storage that's connected to an emergency contact card. So as long as they're enrolled in this plan, they can get cloud storage. And then we have an annual meeting, and then what we call word processing changes unlimited. So you change the names of your trustees, you add and remove an asset in your schedule, you change percentages, dollar amounts, it's all covered under our estate maintenance plan. And I charge $695 for a married couple per year to do that. So a lot of people are like, wow, that kind of makes sense since you have an hourly rate of $610 an hour, that I would pay a little bit more and have like storage, annual meeting, like all that. But nobody has to do that. If they'd rather come back and pay hourly for changes, they can do that too. So I just let them opt in. Now, how much does it cost? Well, gosh, changing a trustee, that doesn't take very much time at all. That might take me like a half hour to an hour and a half. But how do we know it's just changing a trustee, right? Is there an asset that's different? And whenever I amend something, I take responsibility for somebody's situation at that time. So I have a duty to ask these questions. Where are you? His same situation. So good question and very important. Yeah. Yeah, the question is there a maximum number of times you can amend trust? And the answer is no. But I will tell you that there is something that we see a lot of, although it's getting less and less, is that you have a trust with like 20 amendments to that trust. Now, as an attorney, I hate seeing that when somebody passes away, because imagine it's like this big puzzle piece. You're putting a puzzle and you're putting all the pieces together because you got 20 amendments or 19 amendments to the original trust. So it's like, change this article, change that article again. Now change this paragraph of that article. Now add this new sentence at the end of that article. And you're like, oh, I lost track of it. So you have to build out this whole system where you like redo the document. Well, that takes hours to do after somebody dies. So to avoid that problem, after about 3 or 4 amendments, and depending on the complexity of the amendments, I usually do an amendment and restatement. So an amendment and restatement is an amendment of a trust. So you're not getting a new trust, but you amend every single page of the trust. So you get a new document. Totally replaces the prior trust. Great thing, though, for clients who did a trust and put their assets into that trust already. They don't need to move the assets anywhere after doing an amendment and restatement, even though they're getting a whole new document. So you think, you put your house into the trust. You don't have to create a new trust and then move your house into that new trust, right? So an amendment restatement, none of the assets need to move, but you have a new trust document. Okay, what's your question?
Oh, did I hear you right? If you have a health directive, it needs to be updated every 2 years?
Well, technically, the HIPAA authorization in the healthcare directive expires every 2 years. Yeah.
So it could be, so if you have someone that was maybe it's 3 years in, and all of a sudden now you're forced with a do not resuscitate.
Okay, let's be really precise. Let's be really precise, okay? Let's say you have a healthcare directive, right? And it names an agent, and it's not springing, and like it's just immediately effective. Okay. It could go on 5 years, 10 years, 20 years, right? And now you have some problem. There's no expiration of that healthcare directive. Your agent can swing in and make decisions for you, right? But federal law says that HIPAA privacy waivers, once signed, that signature only lasts for 2 years. So let's say that the healthcare directive says, in order to be effective, right, in order for the agent to act for you, the agent has to have a written opinion by a doctor. Now, actually, I don't write my healthcare directives that way. I don't require any written opinion from a doctor in my healthcare directive, right? I do require that in a power of attorney, but I don't require that for a healthcare directive, and it's actually partly this issue. So instead, I say, as soon as a medical decision needs to be made and a doctor determines that you cannot make that decision, then the agent can make the decision, right? But there's no written determination necessary. If we did hypothetically require a written determination, if that HIPAA authorization were more than 2 years old, then a doctor would have to be violating federal law to release a doctor letter saying that you were incapacitated. Oh, like update the schedule where you have the assets listed? Update that schedule of assets where you listed the institution? Right. Well, no, it wouldn't be a valid amendment to your trust to update. Okay, the question is, well, John, what about updating my trust to add an asset to the schedule? Okay, let's be really precise on what you're doing when you update that schedule, okay? When you sign a trust, it'll have attached schedules. If you look at your trust, right, it'll say, I hereby, or similar language, I hereby assign the assets. This is in the body of the trust, which are on the attached Schedule A, okay? If you update that schedule after you've signed that trust with that new language, is that being assigned under the trust that you signed 5 years ago, 10 years ago? No, it's not being assigned. You're not doing any new assignment. So you're not transferring anything to that trust, right? Do you see that? Because when you sign an assignment at day one, that assigns everything that you listed at that time. So you signed that trust, you notarized it, right? At that moment in time, that's what you were doing. If you later write something down, that was not assigned when you signed that trust. But there's another purpose it would help with a little bit, which is that sometimes people don't know what somebody owns at their death, right? So if hypothetically you wrote down an account number, well, at least your trustee would know that you had that account. So it's maybe you've done some good by writing down the account, but it's not a valid amendment. You haven't validly assigned anything to your trust, right? To do that, you'd have to sign a new assignment where you say, I hereby assign this account to my trust. So when people come to me and they're like, John, I have 5 new accounts. Do I need to amend my trust? I say, no, that's overkill. Let's just do a new assignment. We'll put these 5 accounts in an assignment. You'll sign it. We put it in the file because we're trying to avoid probate. And that will avoid probate. There's a case from like year 2000. They said it's the trust schedule or an assignment. So we can do an assignment. Other questions?
In other words, if you change institutions, you have to make a new amendment. Are they going to do that?
Well, have to make a new amendment is really strong words, right? If you go to that institution and you've titled that account in your trust, right? It doesn't matter that you haven't named it in your trust. You will avoid probate. Because remember, I had that screen and I said, what avoids probate? And I'm like, assets in a trust. Naming it in the trust is, what you've done is you've assigned something to your trust, right? When you named it on that Schedule A and it was included in the trust. But you could also just go to the bank and register that account in your trust. Now, your trustee might not know about it at your death. And people are going online, right? And they're not getting paper statements in the mail anymore. It's really frustrating. We're getting more lost property claims. So putting a bank statement in your trust portfolio would be a good idea. Writing something down would be a good idea. But it doesn't change the trust. You haven't validly amended your trust by listing it there. I hope that's clear.